today for our third and final presentation about life transitions here at OceanView. We've had two previous sessions. I hope you've all been able to enjoy them, whether or not it was live here in this room or online on our portal. We have had them videotaped by Brian, videographer extraordinaire, and they are on our portal online, thanks to Dustin, who has put them up. So you can watch them anytime, review them anytime, and I know folks who haven't been able to make the different sessions have watched them or plan to watch them. So we're glad that you're here. It's always good to be educated and learn more about these various topics. And today, as part of the Life Transition series that the OVRAF actually initiated and supported for us to get going, we have an attorney with us, Katie Geoffroy, who has presented here for us many times. And she is with the law offices, used to be Patty Nelson Reed, and now it is called, where is it? Landman Rain Nelson Reed.
That's it.
So it's a mouthful, but they've also moved closer to our campus. They're right over on Route 1 in one of those tall new buildings by Shaw's, so they can be frequent visitors, hopefully. And joining Katie is Michelle Maynard, also the same law firm. And they're going to talk today about estate planning and living wills and trusts and all that legal stuff that we all need in a folder somewhere for the future.
I'm Katie Geoffroy, as you just heard, and I am over the Snowy Hill and just across the street down there at Landman Rain in the Shaw's parking lot. I've been here a few times before. I recognize quite a few people here. So we're going to spend some time today trying not to bore your socks off. So sometimes that's a challenge, but we do our best. And we're going to focus on a lot of things that you already know, but just trying to highlight some definitional terms and things that might be confusing to you so you can have a clearer idea of what they are, the various documents, and also what's new with the law and what you might want to check on the documents that you already have to make sure that they're really going to do what you want them to do. We're also going to try to touch base on what kinds of things you might do to make it easier for people to help you as you get into a more transitional part of your life, that things that you can do now to make it easier for them to be your trusted people to take over for you as things move forward. So I personally don't love standing up here being a talking head. So I hope that if you have a question as we're going along, you'll feel comfortable to ask it. Makes it a little more interactive, which is fun for us. But also we'll be around at the end if you have any questions you would rather not ask in front of all of these people, as I certainly would understand that. So we're going to talk first about the kinds of documents that you want to have in place for during your life. So during your life, you may get to a point where it's harder for you to take care of business or make medical decisions for yourself. And so the documents that we want people to have if they're thinking ahead about this are a medical advance directive and a financial power of attorney. So I'm going to talk a little bit about the medical side, and then Michelle is going to talk about the financial power of attorney and what they do for you. So on the medical side, I bet if I ask you to raise your hand if you have a medical advance directive or power of attorney, I'll get a lot of hands. Oh, that's so great. Look at that. When I started doing this, I don't know, maybe back in the Pleistocene era, I think that oftentimes there would be less than half the people in the room who would raise their hand when I asked that question. So it is, there are forms available. It's really pretty typical for people to have these in place, and it is such a good thing. Because if you have the ability to understand what you're signing, and to want to decide who's going to make those choices for you, you want to pick that person, have the document done, signed, witnessed, notarized, all set, so that when the time comes, the person that you chose to do that is the person who has the ability to show the piece of paper and make those decisions. So it's a way of putting your own autonomy into play. Terms that people get confused about that you may have heard of. I'm going to list 4 of them. Healthcare power of attorney, healthcare advance directive, living will, DNR, do not resuscitate. I get a lot of questions about that. Why are there 4 different, what do these things mean, right? And who do you do these with? Well, a healthcare advance directive is kind of the modern term that covers naming your agent, which is the power of attorney part. Who are you naming to make the decisions for you? Who is the individual? And it's also a living will because it directs those people with your advanced choices about what you would want at the end of life if you were not making the decisions and maybe your prognosis was not so good. So in this one document, a healthcare advance directive, you're going to name who makes the decisions, and then you're going to guide that person. These are the choices I would want you to make for me if you are ever in the position to make those choices for me. If you have an old living will, back from, those started like in the 70s. An old living will was just a one paragraph document that would say, if I'm ever at the end of the road, you can turn off the machines. And that's all. It didn't say who was in charge of the decision. It didn't have anything else in it. So if all you have is a living will, you probably want to look at that and think about bringing that up to the modern standard of having an actual advance directive, naming who makes the decisions, and then providing the guidance. If you haven't looked at your healthcare directive in a long time, it's a good idea to take a look at it. So what if it named your spouse and you lost your spouse? Now you don't really have an advance directive anymore because you don't have somebody in there who's capable of or here to make the decisions anymore. So when we do them in our office, we typically have or recommend that you have 3 layers. I want this agent first, maybe this agent second, maybe this agent third. Sometimes, and actually very often, people will name more than one agent at the same time. So let's say you have 2 kids, and you like to say you love them both equally. You probably do most of the time. But let's say you want either one of them to be able to make a decision. Whoever can be there and be on the spot and do that. Well, if you have an advance directive, you can name them both at the same time so that either or could make a decision for you. And then either one of them can show up and they are the agent. And if they can get to the hospital and help with the decisions, then they're authorized to do that, and they can show that because they are named right there in the first position along with someone else. And so that's, I think, a very helpful, yes? Hi?
What if you've named 2 and they disagree?
That's a terrible situation. So you never want to put 2 people, so she asked, what if the 2 people that you've named are not in agreement? So I've been doing this for a very long time, and I've had one situation in which I had that horrible situation in all of that time. So I find that actually kind of a piece of good news in the sense that I don't think it happens very often because the medical advice is usually pretty clear. But what happened in my case is so instructive to what you're asking. In my case, one of the people was listening to the medical providers and thinking, boy, there really just wasn't much hope of ever this being better, and thinking that it was time to really take more aggressive measures to not be treated and to let somebody go. And the other one just had a different perspective where they thought, basically their feeling was it's God's choice when you take someone. I don't want to be the one doing that. So they were both really in a very, I guess I would call it a good faith way, just didn't agree on what was right. And eventually they worked it out, and they worked it out with the medical people, and the one who didn't want to make the decision just sort of backed away and didn't make the decision, and the other one did. And so it worked out. If you have 2 people that you don't think have the same views of end-of-life choices that you do, that is the most important criterion for who you name. So if you were the founding member of the Dr. Kevorkian Society, you do not want to name someone who could never make the decision that it was time to stop treatment, right? Because they would never be able to do what you want them to do, because that's just not where they're coming from. So, and secondly, if you're going to name 2 people, you want them to feel like they are the kind of people who typically can get on the same page with each other. And then you rely on the medical advice that they're getting to smooth over some of those bumps. But it is absolutely a choice you have to make. Do you choose one person so there's one person in charge with the decision-making authority, or do you like having more than one person on there? If you were really up against it and they were absolutely in disagreement and one really felt like their position was the right one, eventually you end up in court, which, as far as I'm concerned, is a fate worse than death. And so hopefully that never happens to you. So if you're worried about it, you're better off choosing one person than worrying about whether they're going to come to a roadblock. So that the Healthcare Advance Directive, more than one person named, if you can think of enough people that you feel comfortable in a certain order being in charge of your decisions. It's going to specify, you don't have to specify whether you would want treatment to continue if you were at the end of the road. You can leave it blank and then it's up to them. But I think it's kinder to your agents to give them that guidance so they know how to implement what you want rather than guess what you want. But it's your choice whether you fill that part out or not. You can fill in what sort of funeral arrangements you make, whether you want to be an organ donor, who's your doctor that has your basic medical records. You know, there's quite a bit of information in a Healthcare Advance Directive that's helpful to the agent to know. You can decide that it's effective on the day you sign it, and so that if there was a crisis or an emergency for you, no problem. They are right there. They are already activated to do what needs to be done. You can say, I only want it to be effective if my doctor says I can't make this decision for myself anymore. That's just a choice that you have to make. Even if you say it's effective when you sign it, that doesn't give up any of your rights, okay? Signing a Healthcare Advance Directive is not saying, I'm not making any decisions anymore, it's up to Johnny to make the decisions. It just means that he's activated at the same time that you are. If you're making sense and you're able to communicate, you're always going to be able to trump whatever your agent has to say, because you are still completely your own person. As long as you have capacity, you are still in charge. So you're not giving up any of your rights by signing an advance directive. And so I think that's really important, because people sometimes have wishes that they think at this point in their life that they would want no treatment, and then if they're near the end and it's scary, they might not still feel that way, and they might want that treatment. And if you say, I want the treatment, then that's what's going to happen, because you are still in charge, okay? Making medical decisions can often be in a crisis situation, right? And so Maine has passed a law that says if you don't have an advance directive, then there's a series of people named by how close on your family tree they are to you that have priority to be a surrogate decision maker for you. So that's a good thing, because in a crisis, that person might, your spouse or one of your kids or someone who's close to you in some way might have the authority to go in and make a decision for you. But they have to go in and show that they're the one who has that priority and have the ability to make it. So you're making it harder on them. So and then worst case scenario, you have agents who don't agree or no surrogate who's stepping up. Then someone who cares about you can go to probate court and ask to be appointed as your guardian, which is the person who is formally appointed by the court to make your medical and living decisions. And that person gets appointed, and your rights to make those decisions get taken away, because you don't get put under guardianship unless you don't have any capacity anymore to make your own decisions. So in my view, again, the fate worse than death is putting someone who cares about you through the process of having to go to court and take your rights away as the way to make medical decisions for you. That's just truly tragic, in my opinion, when that happens. And the most often time that I see that is when you have a husband and wife who've named each other as their agent, and it doesn't go any deeper than that. And then one of them passes away, and now the other one can't make decisions, and there's nobody who's been appointed. So in my opinion, the thing you want to do, things to think about anyway, are look at your healthcare advance directive, make sure it has people you still want making your decisions, and hopefully 1, 2, or 3 layers deep, and that you're still comfortable with them making those decisions, and that it still reflects your wishes. Other things that I think you can do in advance that are helpful is give them a copy. You know, oftentimes when you do your estate plan, you don't give those documents to everybody because you're not needing that help yet. Well, as you get closer, you're going to want to make sure that your advance directive is on file with your doctor's office, and that it is in the hands of your agent. And these days, mostly people want them as a PDF saved on their phone somehow. I'm sure they know how to find it. It doesn't matter if I know how to find it, right? And then having some conversations with your agents about what you would really want, so that they know what to do when the time comes, and they know how to implement your wishes as best as possible. DNR, we talked about that. Yes, oh, sorry, go ahead.
Since this is a very emotional time, and your agent is probably very closely associated with you, how much do you recommend that they talk to each other to understand exactly what the wishes are?
Yeah. Well, it depends whether you think they're going to know. If it's someone who's been close to you their whole lives and knows what your basic opinions are about this sort of thing, then you may not have to have so much conversation. But if it's somebody who you've just never really disclosed whether you would want to be kept alive or not, and under what situations, then your agent is someone you might want to talk to about that, so that they know how to implement your wishes. Does that make sense? And also the other person you can talk with about that is your doctor. So a DNR, people are always coming to our office and saying, I want you to get me a DNR. Well, I can't give you a DNR because I'm the lawyer. The doctor does the DNR. And it's a do not resuscitate, and it can go through a lot more detail medically about what procedures you would want or not want. Like, yes, I would want to be, what they did to that poor football player, whatever that's called, chest compressions and all that, whether you would want that or not. And it can go then into a doctor's order that goes on your chart and gets posted on your refrigerator. And so a DNR is something that people will often talk with their doctors about as they get closer to feeling like that time is coming. Another form you may or may not have heard of, has anyone ever heard of the POLST form, P-O-L-S-T? Yeah, so physician order for life-sustaining treatment, kind of an odd name for what it is in my humble opinion. But it's kind of, again, a specific doctor's order that goes in your chart that you do with your doctor, not your lawyer, that spells out more specific details of what you would and wouldn't want done. So people tend to do that when they're getting, more sure that they just don't want this sort of treatment, more treatment. And the sort of, I don't know if the last level of that we have available to us in Maine now is the death with dignity law, which you probably have read about, and we're one of a minority of states that have the ability to choose death with dignity. But let me answer this question first, yeah?
Because of the role of the hospitalists now in hospitals, how do you let the hospital know? If you're taken in by ambulance, your doctor may not even know you're there.
Right. So the hospital's typically going to communicate with your doctor's office. Even if you were in the hospital last week and gave them your advance directive, they're still going to ask you if you have an advance directive. So I'm not sure if electronic medical records really works as well as it's supposed to. But someone needs to bring that. You can have it with you, your agent should have a copy, your doctor's office should have a copy, and the hospital will ask if you have one, and that's how they get informed.
Can you ask the hospital to put a copy in your record, your
Yes, you
hospital
can.
record?
Yep, you can. And then somebody just has to look at it, and that's the hard part to control, right? Yes?
You talk about reviewing these documents periodically. Is it okay if they're from out of state, or do they have to be made and signed in Maine?
They do not have to be made and signed in Maine. Maine law says if it's valid where it was executed, it is valid here.
Thank you.
So you do not have to redo it, but the forms are also very widely available. If you just want to make some changes or have it be governed by Maine law, you can do that pretty easily. Yeah?
Thinking about this, being real widely available, and what happens if I'm traveling to California to see kids or whatever. The thought occurs to me that we have signed up with Medical Alert, which is basically gives you a necklace or a bracelet with a code number. And any medical provider in the country knows about Medical Alert, knows to look for it, the EMTs, the hospitals. And so once they get that number, they can then sign on to Medical Alert and have your entire medical record and any auxiliary documents that you've chosen to upload. So that would be a good place to put these documents.
That's a great idea. I had not heard that before, but again, the more people who have your current one, the better the likelihood is that your agents are going to be identified as with a phone number, with who to call, and be able to quickly be there for you. So if it's part of your medical record, and to the extent electronic medical records are working, that's a great way to make sure that your document is with you wherever you are. So I'm actually going to skip over death with dignity just for a minute because it's just too depressing right now. And I want to make sure we have time to cover the financial side of things and the what happens with your will side of things, and then we'll come back to talking about some of the new laws, including death with dignity, as time allows. So Michelle's going to talk a little bit about financial powers of attorney.
How many of you in the audience has a financial power of attorney document?
Look at this.
That's fantastic. Okay. So this is a document that's similar to a healthcare power of attorney in that you designate an agent or agents who can handle your finances for you if you become impaired to some degree and you need help with that. Unlike a healthcare power of attorney, you should not use an online form for this document. I have seen so many financial power of attorneys that were from the internet that are not worth the paper that they were printed on. So it is important to have an attorney actually draft this document for you. And I always get asked, what does durable mean? Because that's in the title of the document that we prepare for clients. And durable means that it survives incapacity. So the principal is the person who signs the financial power of attorney. If the principal in the future becomes incapacitated, the document remains in effect. And the agent is the person who has legal authority to act on behalf of the principal. A lot of people do refer to themselves as the power of attorney, and that's technically incorrect. The power of attorney is actually the document itself. And as Katie had mentioned with the healthcare advance directive, it's also really important that you have some succession in this document. Unfortunately, we see pretty frequently that spouses have named each other as agent and they don't have a backup. And I have a client right now, we have to petition the probate court to become her mother's conservator because that was the situation with her mother. She had a financial power of attorney that named her husband as agent, and he passed unexpectedly, and there's no one else who can act for her. So with a financial power of attorney, it usually conveys very broad authority to your agent to handle all sorts of financial matters for you. So that's everything from paying your bills, signing contracts for you, dealing with your insurance company, dealing with real estate, filing income tax returns. It's quite broad. And you can allow your agent to have a couple of extraordinary powers if they're provided for in the document itself. And one extraordinary power is the ability to make a gift. So your agents are fiduciaries, which means that they owe you a duty of loyalty and they always have to act in your best interest. That normally doesn't include giving away your money or your property. But that can become very important if you do need long-term care in the future and there's ever a possibility of applying for main care to help pay for that care. So it's just important to really understand all the powers that the document contains for the agent. Just like with the healthcare power of attorney, a financial power of attorney can take effect when you sign it. It does not mean that you relinquish your rights to handle your own finances at all. While the principal has capacity, the agent has to act according to the principal's direction. So what I tell people is the agent is really like your employee, and you're the boss. And they shouldn't be acting contrary to your wishes at all. The other option is to have what's called a springing power of attorney, and that only takes effect if your doctor or a judge determines that you're incapacitated, and then the document springs into effect. Generally, your agent isn't liable for good faith mistakes that they may make. They always do need to act in good faith, so they would only be liable if they cause gross negligence or willful misconduct. The other important thing to remember with a financial power of attorney is that you don't name agents that you necessarily love. We tell people that it's good to name agents that you would actually go into business with. And you'd want to name people who have good financial skills, because whatever skills they apply to their own financial situation is what they'll be applying to yours. So it's just very important to carefully consider the agents that you do choose, because there's no supervision of an agent. Things need to get pretty bad for any authority to step in. So in the wrong hands, it is a license to steal. So you do just need to have full trust in the agents that you name. The document can be revoked as long as the principal is of sound mind. So you can always change your mind if you find that maybe the people I chose 10 years ago are not the people I would select now. The document can be changed. Is there any questions about a financial power of attorney?
I have one.
Yeah.
Who determines capacity?
If the document is effective immediately,
I mean, if there's, say you name a child as your agent, and they argue that you don't have capacity, but you think you do, and perhaps a doctor does. I mean, I'm just curious who defines who has capacity and when and how.
yes, most likely it would be a doctor that makes that determination if there was any disagreement as to whether or not the principal could still act for themselves or their agent should be acting on their behalf.
Yeah, it would usually be the doctor, although in a really bad situation where they're in complete dispute, that's where you end up in probate court trying to decide whether the principal still has the capacity to revoke this document or not, and that's really a nightmare. So there's a legal aspect to capacity as well as a medical one, but it's on the first level, it is the doctor who's kind of saying, you know, if it's a springing power of attorney and you're trying to decide if this person, if this is in effect now or not, it's typically from the doctor that you're going to get that determination. And if you have a springing power of attorney, what does that look like? Here's a springing power of attorney. Attached to the back of it is going to be a letter from the doctor saying, you know, the principal can no longer manage his or her financial affairs. You have to, you know, if you want to make it easy for the agent, you want to put those two things together, because that's what they're going to have to show to the bank or to, you know, whatever financial institution in order to be able to use the power of attorney.
One downside to having a springing power of attorney that Katie was starting to allude to is that a lot of financial institutions will not accept a doctor's letter or certification of an incapacity because, you know, capacity is not a stagnant thing. It can change. So your agent may need to periodically go back to your doctor and get a new letter to document incapacity. So it is more of a burden for your agents to have a springing power of attorney. Yes?
I know of a situation where the individual's child is the logical choice for power of attorney, but probably needs occasional supervision. Would it be possible to, for instance, make an attorney involved in each decision only from a supervisory standpoint and within certain limits to kind of keep an eye on things?
Usually when we have gifting provisions in our power of attorney, we do counsel clients to think about limitations on that power because it's so important, it can be misused. So in that respect, we often will put a limit on how much the agent could gift without first seeking approval from an elder law attorney. But to be honest, we don't have other limitations that frequently in the documents. And I would say if you're that concerned about the agent needing a lot of supervision, they're probably not the best choice. Or you could have co-agents who would have equal authority if you wanted more of a check and balance on that particular individual's ability to act for you.
Could you have the co-agents both have to agree?
You can provide for that in the document, and we've also included provisions saying that if there is a disagreement, then, person X decision controls. So there have been circumstances where you can get pretty specific in the document. It is meant to be tailored to, what the principal wants, so.
Another thing we've done sometimes, which is sort of interesting on that, is you can name two agents jointly, but now every check has to be signed by two, so it can be really hard to use. So sometimes we do joint action, but with delegation. So we might say, Fred and Susie are the co-agents, and they must act jointly, but they can delegate transactions less than $500 to one or the other of them as long as they both agree. So that can take away the nuisance factor for this sort of day-to-day banking stuff. But bigger decisions would have to be made together. So you can really tailor the document to what you need to feel comfortable with who you're naming.
This might be an old-fashioned term, but is this agent, the power of attorney, the same as the executor of your estate, or are they? Because I realize the power of attorney can, any of us could be alive, and that person is already swung into action, so to speak. Whereas, but if you could explain the difference, I'd appreciate it.
Yeah, that's a great question. So a power of attorney is in effect only during the principal's lifetime. So it ceases to have effect upon death. Now, oftentimes the principal will have named the same person as agent under the financial power of attorney, as executor or personal representative under their will. But they are separate documents that take effect at different times.
Which is often surprising to people.
Yes.
I've had many, many agents who say, I had no idea my power of attorney wasn't good anymore after my mom died. So it can be surprising. So it's great to understand how those different roles have a timeline.
Yeah. So similar to a healthcare power of attorney, if you don't have an agent named in a financial power of attorney, your family members may need to petition the probate court to become your conservator. There's nothing similar in Maine law that allows your family members to act for you regarding financial affairs. So there's no surrogate decision-making for finances. So the financial power of attorney is extremely important to have. And again, with the conservatorship, you do have to prove incapacity in court. Because of the new law, there's a much higher standard that you have to meet. And it's, somewhat adversarial. So it's a lot of pressure on the family. It's expensive, and it can be a more time-consuming process than you would anticipate. So going to probate court really should be the last resort and avoided, if at all possible. Oh, one other thing I just wanted to mention, if someone does have to become a conservator for someone, the court does remain involved. It's not like you go to court, there's a hearing, you're appointed, and the court says, off you go, you're good. The court requires annual accountings and report from the conservator. So again, the burden is just ongoing if you do have to go that route. It's good in a way that the court remains involved and there's some level of supervision, but for a good faith family member, it's more effort and expense.
On that surrogate decision-making, I've had lots of husbands and wives come to me and say, Well, we own everything together, so we don't need power of attorney because we're both on everything. Well, what happens if they got sick, both of them, and it was time to sell the house? Well, they can't act for each other. And even if one of them was fine and one of them was sick, just because you own the house together you have no authority to sell your spouse's half of the house. So, and you have no authority to take a withdrawal from their IRA, even if there's a required minimum distribution. You have nothing you can sign. Even though you're the beneficiary when they die, it's not your IRA during their life. So you really have to put this in place. And you all have them. I mean, I think almost 100% of the people in this room raised their hands. But look at them. Make sure you have some layers. Make sure that they were hopefully done with an attorney and are, as broad as you are comfortable making them. If you don't want it to be super broad and you don't want your agent to have gifting authority, that's fine. But having them be able to pay the day-to-day bills and make financial decisions if you become incapacitated is really, really important. Any other questions on
Yes.
powers of attorney?
Can you give a little more information on benefits or disadvantages of springing power of attorney versus the absolute one? Thank you.
Yes, good question. So with the springing power of attorney, what I find most often is that it's younger clients who don't feel like this document will really be used in, the next 10, 20 years. They're more comfortable with the springing, power of attorney. There's also some people who really value their privacy, and they don't want their agent to be able to present the document to a financial institution and for them to have access to information about their accounts. So it really depends on, what your values are, what your preferences are, and just how comfortable you are with your agents having access to information. Because if you do have a power of attorney that takes effect immediately, it is possible that your agents could begin acting for you and have access to that information.
And sometimes a compromise on that has made some of my clients happy is the idea of we sign it, it's effective when signed, but they don't give a copy to anyone. And they give us instruction as the holder of the copy or the original to check with them first and make sure that they're comfortable with it if somebody comes to our office and asks for a copy of it. I mean, we're never going to give it away without checking unless they've told us it's okay to give it away. So you can say, hopefully after talking with an attorney, they're choosing someone who's trustworthy. And so it's more the concerns about the bad stuff you read in the paper or the stuff you hear from other people who had a bad power of attorney, or even a good TV drama, where somebody stole all the money and whatever. And that's not necessarily your agent. So you can make it effective when signed so that it's easy to use when they need to use it, but maybe just don't give them a copy and make it a little harder for them to get a copy to make sure it's the right time when they do need to use it.
So we'll turn to the documents that take effect upon death. So I'm very loosely following the outline, but page 4 is where it would start. So we get a lot of questions about living trust, and it's a will alternative. And a living trust is a way for you to set up management of your assets in case you do become incapacitated, and then for after your passing as well. So with the living trust, it's really your alter ego. You are the grantor, you create the trust. You are the trustee, you manage the trust, and you're the lifetime beneficiary. So it's really all about you. You still have full control over all the assets, but you transfer your assets into the name of the trust during your lifetime. And there's a few reasons some people like to do this. One is if you're in a state where probate is a nightmare and you want to avoid probate at all costs, people often have living trust. Another reason people do this is if they're concerned about some potential will contest. You know, if you have some relative who's a troublemaker, and even though they have, you know, they shouldn't think that they're entitled to anything from your estate, but you just know that they're going to cause a headache for your family, a living trust is probably the way to go. Or if you want to keep your estate plan private, a living trust is not published online anywhere like a will is. So if you are treating your children differently or disinheriting a child or something like that, and you don't want the world to know about that, you can have a living trust. And if you want also a professional to manage the trust, if you want a professional trustee, a bank or a trust institution, it's often easier and better to do a living trust. The real downside to a living trust is that the expense and the work is done at the front end. So you have to make sure that your assets go into the trust and is properly funded. Otherwise, you haven't really accomplished all of your objectives. And probate could still be necessary if there's assets that didn't make it into the trust before your death. And having a living trust does not do anything to protect your assets from long-term care costs. So a lot of people here, you know, if you ever need to apply for main care to help for long-term care costs, the best thing to do is create a trust. And this is not that type of trust. It does not protect any assets from that. So the other option is to have a last will and testament, and that document takes effect upon death. So it can be changed at any time during your life as long as you're of sound mind. And if you want particular assets to go to particular individuals, then of course you need to have a will or the living trust, but you need a document to make your choices known. In Maine, probate's necessary when a legal transfer of real estate is involved or the assets in the estate, the probate assets, exceed, I think this year it's $47,000. So a lot of people mistakenly think, oh, if I have a will, then I've avoided probate. That's not the case. It really depends on what assets are owned by the estate. With a will, you can name your personal representative. It used to be called executor. It's the same role, so you can name who will handle the estate administration process after you're gone and make those your wishes known. So a will, even if it's 50 years old, if it was valid when it was executed, it remains valid today, but you may want to look at your documents to make sure that they reflect your current wishes. A lot of people tend to do wills after they've had children, which makes sense, of course. You set up a trust for your children, and then you don't think about your will for the next 30, 40 years. So it's a good idea to go back to those documents and just make sure that both the estate plan makes sense for your current situation and the people that you've named as personal representative, and if there's any trust in your will, there's the people that you'd want to act now. And then, of course, if your estate exceeds a certain amount, currently the estate tax exemption in Maine is very high. It's $6.4 million. But if your estate is approaching $2-3 million, then you may want to have some optional tax planning provisions in your will or your living trust. So that's a very broad overview. Yes?
Do you need both a living trust and a will?
When we do living trusts for people, we have a very simple will called a pour-over will that just is there in case any assets did not make it into the trust during your lifetime. And what that pour-over will says is any of those orphan assets gets poured into the trust after you're gone.
Let's think about some typical examples. Let's say you have an IRA and you have a joint account with a spouse or a child, and you have a beautiful camp on a lake in western Maine. I can be there anytime that you say is good with me. And you have a life insurance policy. So kind of typical assets, right? chances are your real estate is in your name. And that's typically going to be a probate asset unless you put it into the trust during your life by signing a deed, transferring it from you to the you trust. Then it's already in the trust and you don't need probate to get it there. If you have a joint account, that's going to belong to the surviving joint owner, right? So that's not going to come through your will unless the joint owner died. And then it is going to come through your will. So if you have a joint account with your spouse, you might want to name your trust as the payable on death beneficiary of that joint account so that it goes into the trust automatically at your death and isn't vulnerable to having to go to probate through your will. IRAs are typically going to have a beneficiary. Almost no IRA holder will let you open up the IRA account without saying, who's your beneficiary? And it's much better to have a beneficiary on an IRA, much, much better from a tax standpoint. Life insurance, if it names a beneficiary who's living, that's who it's going to go to. If it names a beneficiary who's deceased and there's no backup beneficiary, then sometimes under older policies, it'll say it goes to a surviving spouse, and if there is none, it goes to the kids. But that's less common. More common is it's now going to pay to your estate. Well, you're not going to have an estate unless that will goes to probate. So you have a pour over will because of these in-case situations where or you maybe got a new asset after you worked with the lawyer and you put everything in the trust and you thought you were all super duper and ready to go. And then, you opened a new account at the bank and you forgot you were supposed to name the trust as the beneficiary of that account. Or you get a new asset. So typically you want the pour over will in case, but you want to pay attention if you have a living trust to having made some deliberate decisions to put things in the trust or make them payable to the trust at your death so that you don't have a fancy schmancy trust and you still have to probate the pour over will, and now you kind of have spent more money than you should have getting the assets where they need to go. Does that answer your question? Yeah. So I'm gonna talk about some new things. So one of the things, yep.
I have a really basic question. I know our age group, we were told to put everything in a trust. And then when I moved to Maine, the lawyer that I spoke with said, it doesn't have to be in a trust. It's just, so why?
Why? So the difference is the probate process in different states is just very variable. So in some states, courts supervise the process of probate very closely, and you have to have a lawyer go with you and go to hearings and have the judge approve the distributions, and it's very expensive to do it that way. In Maine, we don't have that. We have an informal probate process, which means that you file the will and some other paperwork in the probate court, and you get appointed and you do your job, and then you close the estate, and the judge never sees it unless there's a controversy. So when Susie Orman and lots of people from Massachusetts or California say you would be crazy not to have a trust, it's because probate in those states is really challenging and expensive. And I would say that Maine does not have a challenging or expensive probate process. I mean, I'm always laughing at this with my clients. I've never had a client say at the end of probate, oh, that was fun, I hope I get to do that again soon. That has not yet happened, but hope springs eternal. But it's really a relatively straightforward process here. So, and it also is a tidy process. Like, you collect up all the assets, you make sure all the bills get paid, you have a creditors period where anyone who has a bill against your estate can bring that bill forward and get paid, and then the will governs how the assets are going to be distributed. So going through probate, again, not fun necessarily, but it is a tidy way to clean things up and make sure the money goes where it's supposed to go. It's also a great way to make sure that assets going to someone who may need help managing it go into a trust instead of to that person. So it's not that probate is universally bad. It's that it is very different from one state to another. So what you hear or might have heard in one state may not be the same as the advice you get here.
Related to that question, wouldn't probate take more time? I mean, aren't there advantages to having a trust in Maine?
You want to do that? You want me to do that?
Yeah. Probate, informal probate in Maine takes generally between 9 and 12 months. But a lot of that is inactive time. The creditor's period is 4 months, and not a lot happens during that time. So yes, administering a living trust can be much more efficient. Again, it's just, what your preference is.
And if you don't have a lot of creditors, which, in this age group, honestly, we typically have paid our bills and we don't expect to have any weird creditors. But if you have a will that went to probate, you have a 4-month period for creditors to make a claim. If you don't go to probate, it's because you did everything through a trust or you had beneficiaries on everything, it's a 9-month creditors period. So you can't be sure there won't be a creditor until 9 months from date of death if you don't probate the estate. So to the extent you're worried about creditors, doing the will and the probate is a better choice because the period of time is shorter. Isn't that just bewildering? Mm-hmm. Yeah, I know. So I'm going to talk for just a minute more here about some new laws. So I mentioned the Death with Dignity law, and I want to just say a little bit about that because I think it's such an interesting law. And I think it's certainly not a choice for everybody, but there's a couple fundamental things about it that I think people should know. So one is, in order to use the Death with Dignity Act, you have to have capacity, and you have to make the decisions, and you have to be able to administer the medications to yourself. You cannot name an agent under a healthcare document that has the authority to do this for you if you become incapacitated. It's only the person themselves who can choose death with dignity. And if you do choose it, you have to go through a process, and it's, they give you quite a few waiting periods, and you have to review it with your own doctor and another doctor and another. It has a process to it to be sure that you're not just having a bad day, okay? And I've so far had only one client who's used it. And I wasn't involved in the process. He did it with his family. It was really something he did with his doctor, but he had ALS, and he knew he was just going to get less and less well. And the report I heard back from his family is it wasn't that bad of a process to go through, and it was really a wonderful family experience that they could choose the time and all be together. And, it was not a good situation, obviously, but it was something that was really a nice tool that he wanted to take advantage of. So Death with Dignity we've had for 3 years now in Maine. I don't know what the numbers are on how many people have used it, but I imagine it's not a whole lot. Other new laws that are interesting are 3 years ago, again, 2019 was a very busy year in the legislature when it comes to this practice area. We now have the ability to do something called a transfer on death deed. So if you own real estate and you want it to go to your son at your death, and let's say you only have one child and you really don't want to bother with probate for everything to go to one person, and you want to just make everything have a beneficiary. You never used to be able to do that with real estate. You could either transfer it to him during your life, or you had to go through probate. Or put it in joint ownership. And those are risky from a long-term care planning standpoint, and also from just having your own assets. So the transfer on death deed is an interesting option. It's a revocable deed, meaning you can put it on file and then you can say, yeah, I don't like that anymore. I'm going to take that back. And you can take it back. You can put it on a piece of property even if you have a mortgage on it, because you still are the owner of the property, and you can still sell the property. And you can still take out a home equity line on the property, because there is nothing about the transfer on death deed that takes effect until your death, and only if you haven't revoked it during that time. So you have to create it, sign it, and have it recorded before your death in order for it to work. But it is a way to pass real estate to a beneficiary, just like you name a beneficiary of your IRA and your life insurance policy. So it's an interesting way to have that type of property pass at your death. And then the last law that I just want to mention is the Secure Act. Anyone heard of the Secure Act? A few people, yep. So the Secure Act passed while somebody was busy trying to be impeached, can't remember who it was. And the Secure Act changed the distribution rules for IRAs and retirement accounts generally. And so it's not really going to affect you so much, but it's going to affect your beneficiaries under your pre-tax dollar accounts. Under the old law, you would name those beneficiaries, and when they inherited at your death, they would take their share of your IRA. You know, let's say it was 3 beneficiaries. They would each get a 1/3 inherited IRA. And that inherited IRA, even if they were only 42, they would have to take a minimum distribution out of that IRA every year based on their life expectancy. So they didn't have to take very much if they were a young person, right? Now the IRS said, I'm tired of waiting for my tax money, and I'm ready for my taxes to come in sooner. So now if you have a beneficiary who doesn't fall into a special category, they have to fully withdraw their IRA money from you within 10 years of the year of death. So that's a lot faster than somebody with a 40-year life expectancy. So all that really means is that it doesn't apply to your spouse, so your spouse can still roll over the IRA. They're one of the special beneficiaries. Doesn't apply if you have a disabled or chronically ill beneficiary. Doesn't apply if you have a minor child. So there's a few, and then there's a few other small exceptions. But the concept is the IRA money is going to come out faster after your death than it used to. Do you care about that? Maybe not. But what I tell people who have significant IRAs is you are a retiree. You might be in a much lower tax bracket than your kids are going to be in when you die and they're at the peak of their careers, earning mega millions, let's hope, right? Because that way they can pay for all the stuff that you run out of money for, because that's really what you're looking for in children, am I right? Anyway, so it's just tax planning wise, it's good to know that this is out there, because you might want to take more out of your IRA even than the minimum if you'd rather have that tax hit fall while you're at your retiree income bracket rather than falling at your kids' income bracket, which might be worse than yours, and now you're paying more tax on that IRA money. It's not something you come talk to your lawyer about. I just am surprised how many people haven't heard of it, because there was so much going on when it passed. And so it's something you would talk with your financial person about, but I think it's just good to be educated that that was a pretty significant change in the law in the last few years.
I just want to make a comment about the death with dignity law, because we happened to have a meeting here about such things. And for me, the most significant thing is that it is only for terminally ill people, and those with dementia do not count.
That's right.
They can't use it. And
They can't, because they can't be the decision maker if they have dementia to the point where it's terminal. Exactly right. Yep.
Related to what you were saying with the new law that you have to withdraw within 10 years, does that also apply to Roth IRAs?
No, the Roth IRA doesn't have, you don't pay tax on the Roth IRA when it comes out, so there's not going to be a difference in the tax bracket because you're not paying, you paid taxes on the front end going in.
But do they have to dissolve it within 10 years?
I don't think so. Do you know that for sure? I don't think so. Because the IRS wouldn't care about that, because they're not, they're not getting any tax money from that.
Yeah, I'm just still a little, I will read more, but assuming the kids, the beneficiaries have to take that IRA within 10 years, and say it is significant. So they're paying taxes, or because the IRA was pre-tax money?
Exactly. So when you take money out of your IRA, you pay the income tax on what comes out because it's never been taxed. When they take it out, they have to pay that same tax. It's not an extra tax. It's the same income tax as you would have paid, but you're choosing whose tax bracket it's coming out under.
Right, but you're intimating that somehow to avoid that, you just take all the money out of your IRA, but I can't figure out where you'd put it.
Right, so if you took it out of, what people do when they want to deal with this issue is they take more of their IRA out every year over a period of years and put it in their non-IRA investment account or some other investment or a CD or a bond fund or whatever they're going to put it in. so that it's already paid its 100% income tax when it came out of the IRA. You follow me? Yes. Okay. Yeah.
Something you may want to consider is converting your IRA to a Roth. If you can afford it, it would really be beneficial for your kids.
Okay, so when you do that, you pay the income tax, now it goes back into so you have less money because you paid the income tax, but now it goes into a Roth where when it comes out, it is not going to be taxed again because the tax has now been paid. Exactly right. And again, I wouldn't know how to do that. That's not something that lawyers do. That's something that your financial person does. But it's useful if you want to, just to let you know, to maybe have a conversation with that financial advisor about it if you're interested. Well, I think we did pretty well on the timing, I'm going to say. So there's more information in your handout about sort of general VA benefits issues, main care basic rules. You know, those are, we knew we wouldn't have time to cover those today, but we included those so that you'd have them in case that's fun to read. I don't know why it would be fun to read, but who knows. The question was whether you have to renew your DNR every year. And I don't believe that's the case, not that I have ever heard. So that seems crazy to me. What often gets renewed and maybe is confusing about that is when you go on hospice, you're supposed to be expected to not be with us within the next 6 months or 9 months or whatever the number of months is. And so that would have to be renewed. And I suspect it's confusing those two things that make this what you've heard.
I'm Tom Belknap. I'm the president of the Resident Assistance Fund, and on behalf of the fund and actually all of the residents here, I just want to thank Katie and Michelle for a fantastic presentation.
Oh, thank you.
And also to the OceanView staff for putting this series of 3 presentations on for us. It's been extraordinarily informative and useful, and thank you very, very much.
Well, that's nice to say. Thank you.
Thank you both again. We really appreciate the information. You do have contact information for both Katie and Michelle if you have further questions. Again, they're right here in Falmouth. And thank you so much for coming. It's always a pleasure to see all of you. Take care.